This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we explain why denial of a claim alone is not evidence of bad faith, and that an insurer that relies on the expert opinion of a qualified engineer can avoid a claim of bad faith. Where the court held that denying a church's claim based on an expert report is not evidence of bad faith. Lakeside Evangelical Congregational Church sued Church Mutual Insurance Company, CMIC, for breach of contract and for bad faith stemming from CMIC's alleged failure to provide insurance payments for roof damage caused by hail. CMIC moved to dismiss Count 2, the bad faith count of the suit. In Lakeside Evangelical Congregational Church versus Church Mutual Insurance Company, the United States District Court of the Western District of Pennsylvania on March 3, 2025, applied the rule that an insurer relying on an expert report is not acting in bad faith when it denies a claim. Lakeside alleged that the roof of its church sustained wind and hail damage from a June 16, 2022 storm. CMIC denied the claim based on the opinions of its forensic engineer, James Graf, who concluded the damage to the roof was not the result of hail damage, but rather the balding and blemishes on the roof shingles were consistent with a manufacturing defect, a non-covered cause of loss. Lakeside alleged that because CMIC refused to pay benefits pursuant to the policy, CMIC breached the insurance contract, for which Lakeside claimed damages in the amount of $146,016.72. In addition, the First Amended complaint alleged that CMIC acted in bad faith. The basis of the church's suit was that its public adjuster opined that CMIC acted without justification in regard to their insured's rights under the policy of insurance, totally disagreeing with CMIC's expert. A claim has facial plausibility when the plaintiff pleads factual conduct that allows the court to draw the reasonable inferences that the defendant is liable for the misconduct alleged. The purpose of a motion to dismiss is to streamline litigation by dispensing with needless discovery and fact-finding. CMIC argued that Lakeside's bad faith claim should be dismissed because its reliance upon Mr. Graf's engineering report provided a reasonable basis for its denial of Lakeside's roof hail damage claim. To succeed on a bad faith claim, a plaintiff insured must prove by clear and convincing evidence, one, that the insurer did not have a reasonable basis for denying benefits under the policy, and two, that the insurer knew of or recklessly disregarded its lack of a reasonable basis in denying the claim. An insurer simply must show that it had a reasonable basis for coverage decision based on the information available at the time the decision was made. Reliance upon an expert report is a reasonable basis to deny an insurance claim. The insurance company is not required to show that the process by which it reached its conclusion was flawless, or that the investigative methods it employed eliminated possibilities at odds with its conclusion. The basis for Lakeside's bad faith claim stemmed solely from CMIC's decision that hail damage was not the cause of the condition of Lakeside's roof. Lakeside's criticism of Mr. Graf's report derives from Lakeside's public adjuster, Jason Cortazzo's disagreement with the report. The court noted that regardless of which, if either expert opinion is ultimately determined to be correct, for purposes of a bad faith claim, CMIC is entitled to rely upon its own expert opinion in relation to the decision it made. Under these circumstances and allegations, Lakeside's amended complaint failed to support a bad faith claim. Accordingly, CMIC's motion to dismiss Count 2, the bad faith count of the amended complaint, was granted and dismissed without prejudice. In my opinion, to prove a case for the tort of bad faith as alleged by Lakeside, the insured must show that the insurer wrongfully, maliciously, unreasonably, and recklessly refused the claim. In this case, the insurer relied on the expertise of a qualified engineer, and the insured relied on the expertise of a public adjuster, who may or may not have been qualified. Regardless of which expert was correct, relying upon a qualified expert's opinion is evidence of the good faith of the insurer who made its decision based on a competent expert's opinion, creating a genuine dispute between the insurer and the insured, so that the claim was fairly debatable and that the decision of the insurer was appropriate. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 5,000 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe to the blog or the videos or both. They're all free. And if you're interested in more detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.